Friday of this week, I did a rant about how the Supreme Court was never given the power to overturn laws based on the Constitution. That clip went up over Democratic Underground yesterday, and it was up today this morning. And there are comments that I'd like to respond to. The first comment was from Elling, or E-L-L-E-N-G, who quoted from Wikipedia, not exactly a reliable source of constitutional information, saying, quote, federal and state courts at all levels, both appellate and trial, are able to review and declare the constitutionality or agreement with the Constitution or lack thereof of legislation that is relevant to any case properly within their jurisdiction. End of quote from Wikipedia. That was the comment about what I had to say. Well, yeah, courts do claim that power, but notice this carefully. None of the people who commented on DU, as of a couple hours ago, I haven't looked at it since I went on the air, actually quoted the Constitution, saying that any court has the right to overturn laws passed by Congress and signed by the president. The reason why nobody said that over at DU? It's not in the Constitution. Please read it. The Constitution. The second post was from Marshall, who quoted Nixon saying, when the president does it, that means it is not illegal. Well, Nixon did say that. But it wasn't the Supreme Court that overruled him. It was Congress, which passed a whole slew of, well, actually, Congress was fixing to impeach him, and that's why he resigned. He knew that. And then after he resigned, Congress passed a whole slew of campaign finance and transparency laws in the wake of Watergate. That's the appropriate role of Congress, to pass laws. If Marshall meant to imply that the Supreme Court is necessary to stop a rogue president like Nixon, then I'd like to make 2 points. The first is that the Supreme Court didn't stop Nixon, and under the Constitution, they can't. It's the job of Congress to impeach or remove a president from office. Again, please read the Constitution. Second is even more important. The reason why early conservatives at the Constitutional Convention did not allow the people to vote for U.S. senators or for the president. Keep in mind, at the beginning of this country, at the founding of this country, and right up until 1913, senators were appointed by politicians in each state. And the president is, to this day, is elected indirectly by the Electoral College. Only people directly elected are members of the House and Senate, or members of the House of Representatives in the original Constitution. And that was because the conservatives in that day didn't trust we the people with the full reins of government. They also thought that the senators should represent the interests of the rich, like in the British House of Lords, which the Senate was based on, while the House of Representatives, which is directly elected, could represent the interests of the average person, like the House of Commons in the UK. Commons, the commoners. Thomas Jefferson and many of the other founders fought this tooth and nail. They didn't think there should be a ruling aristocracy in America, but that they thought that all decisions should ultimately be made by we the people every 2 years in elections that either kept politicians in office or threw them out because they made bad laws. Jefferson wrote a brilliant and rather long letter to his old friend Samuel Kercheval about this, about the appointment of senators instead of their being elected. He said it was the first, quoting Jefferson, quote, Republican heresy, small r, in this first essay of our revolutionary patriots at forming a constitution, end quote. Jefferson added that because of John Marshall's Marbury decision in 1803 that gave courts the power to strike down laws, remember, it's not in the Constitution, that because of that decision, the courts now had even more power than the executive, the president. He wrote, a faction once possessing themselves of the bench of a county can never be broken, country can never be broken up, but hold their country in chains, forever indissoluble. Yet these justices are the real executive as well as judiciary. In other words, Marshall, your law is that the people can't be trusted to throw out politicians who pass unconstitutional laws, and therefore we need to have 9 all-wise people on the Supreme Court to decide whether any law will stand or be rejected. That isn't democracy. That's a kingdom with the Supreme Court justices as kings. Do you really want that kind of a country? Remember, you can't vote the Supreme Court out of office. In that same letter, Jefferson talked about how the appointed Senate and Supreme Court would defend the rich. as the Senate did until we amended the Constitution during the Progressive era, the 1913, so that the people could directly elect our senators. But back in the late 18th, early 19th century, Jefferson wrote that he and the other progressives of his era wanted the people to have the most power. Quoting Jefferson, quote, "Their object is to secure self-government by the republicanism of our Constitution, as well as by the spirit of the people, and to nourish and perpetuate that spirit. I am not among those who fear the people. They, and not the rich, are our dependents for continued freedom." End of quote. But back to the comments over at DU. Lars77 said, "Well, a buck needs to stop somewhere. Plenty of things the founders did not anticipate. In a functioning democracy, the Supreme Court is not corrupt and therefore would be competent to handle things like this." End of quote. Actually, the founders did anticipate this, and they rejected it. Read Madison's notes on the convention, on the Constitutional Convention. The buck for all lawsuits does stop somewhere, the Supreme Court. It's in Article 3, Section 2 of the Constitution. But the buck of what's constitutional, that is not a power given to the Supreme Court. As Jefferson pointed out, that is way too much power for 9 unelected people serving for life to have. The founders of this country did not want us to have kings and queens in America striking down laws passed by the representatives of the people. And that's why they didn't give the Supreme Court that power. Again, read the Constitution. If Congress passes an unconstitutional law, the people will rise up and protest and throw the bums out, and a new Congress will fix it. Or the president actually does have the power under the Constitution to veto a law passed by Congress because he thinks it violates the Constitution. But not the Supreme Court, because they're not answerable to you and me. And this isn't supposed to be a kingdom. Spectator said over at Democratic Underground, "It's called balance of power, 3 co-equal branches in theory." Actually, those phrases never appear in the Constitution. Nothing about balance of power in the Constitution. The first among equals, Article 1. The first of the 3 branches of government is the legislature. They and only they have the power to tax and spend and create laws. Second among equal, the president, has the job to carry out laws Congress passes and can veto laws he thinks are unconstitutional. And the third among equals, the Supreme Court, is, as the Constitution says, the final court of appeals. So if you and I have a lawsuit that goes from court to court, somebody finally has to have the final say. Again, it's in the Constitution, Article 3, Section 2, which even puts the Supreme Court under the regulation of the first among equals, the Congress. Here's the language from the Constitution that I'm encouraging you to read. Quote, "The Supreme Court shall have appellate jurisdiction," right? The final court of appeals, "both as to law and fact, with such exceptions and under such regulations as the Congress shall make." End of quote from the Constitution. Read it. So I stand with my argument that legal scholars from Thomas Jefferson to the current dean of the Stanford Law School, Larry Kramer, make that the Supreme Court does not have the constitutional power to strike down laws. That power resides with you and me. It's called elections. Again, please read the Constitution. Nowhere in there will you find anything that says that the Supreme Court has the power to strike down laws passed by the House, the Senate, and the President. All, by the way, who are elected and answerable to us, unlike the Supreme Court. This is a constitutionally limited representative democratic republic, not a kingdom ruled over by 5 out of 9 people sitting for life on an unelected Supreme Court. The court has been acting illegally for centuries, and Congress should take action to stop it, as Presidents Andrew Jackson, Abraham Lincoln, and Franklin D. Roosevelt tried to do. Wake up. Read the Constitution. We'll be back.
This is the Thom Hartmann Program.
So, my rant. And what's so bizarre, I agree with Newt Gingrich and Phyllis Schlafly on this.